Welcome back, everybody, to Magnolia on Money, where we discuss everything financial from the economy to retirement. And I'm Ed Cox with Magnolia Wealth. Today, we're going to continue on our path, the 5 financial pillars of a financial plan. And we are on the estate planning portion of the 5 pillars. This is number 4. Pillar number 4 is estate plan. And so we're going to dive into the trust side of that. We're going to discuss, a couple of different types of trust. Last week, we touched on wills and then the DoNothing Plan, and I'll review that real quick this week. But let's dig in, and I think this will kind of clear up our estate planning the best we can. All right, so I'll get my laser pointer in case of that. So we have income planning, investment management, tax planning, estate planning, and asset protection. We are on number 4, which is estate planning. Last week, we discussed the 3 main types of estate planning that we see here in the office, either the DoNothing Plan, which is you don't do any kind of planning, WillBased estate plan, and TrustBased estate plan. Last week, we dug into the first 2, and just to rehash that really quick, the DoNothing Plan, you die intestate, meaning without a will, and in Alabama, the state has a plan set up for you. And in most cases, in most states, they're going to have laws set up that if you don't have any estate plan, it's going to go by the letter of the law that states this is what happens in the instance that somebody passes away with no plan. And a lot of times that is not the plan you may want to happen. Then we have a will-based estate plan, and we talked about the main parts of a will-based estate plan. You may not have all of these, but in a total plan, when you have a fully executed will-based estate plan, you're probably going to have most of these addressed with the attorney. The will, the general durable power of attorney, or springing power of attorney. You're going to have a living will, healthcare power of attorney, HIPAA documents, memorial instructions, things like that. So these are the basic documents that we typically see in a fully executed will-based estate plan. There are some disadvantages, and we went over those last week. You know, it's not private. Probate's a long-term process because a will has to be probated. If you have properties in multiple states, it'd have to be probated in each state that you have those properties. So there's some things there that are disadvantages. Let's talk about a trust-based estate plan. In general, a trust-based estate plan. So a trust expresses your wishes, similar to a will. It says how you want assets to be divvied up, and it's pretty straightforward, just like a will. Can avoid probate at death and incapacity. Now, I always say can because it has to be set up correctly, and all assets have to be in their right place and titled correctly, but it can avoid probate at death. And then a lot of times we don't think about or talk about probate at an incapacity situation. You are in this scenario, you would not be dead, but you would be in a health situation where you could not make financial decisions, healthcare decisions, and so if you did not have instructions in place, then you would have to go through what is called living probate to determine who is going to take care of your finances and who is going to take care of you. So it can avoid that. It can provide asset protection depending on the type of trust that you set up. And those asset protection normally falls under these 3 categories of lawsuits. If you're in a long-term care facility, a lot of times people set up trust to help protect assets from that. And then estate taxes is typically the tax that we're dealing with when we set up trust. It is easier to administer, typically, during a death or incapacitation situation, mainly because we do not have to go through the probate court. We don't have to go to court to figure out what's going to happen. You've already taken care of that in your trust. And so that typically makes it easier. You keep your information private because the trust is not probated. then the documents are never open for public record, so they can look at it. Trust typically costs more to create. I've seen trusts that cost 10 times more than a will does to create. I mean, trust can get really, really expensive really fast, depending on how complicated you make the trust. And is it for a couple, a single person? So there's a lot of, details that would need to be worked out, and that also changes cost. So that's kind of a basic trust-based estate plan, kind of some of the nuances there. And then I think the last one here is you can have limitations, or typically there will be limitations to control your assets, depending on the type of trust again. So, and we're about to get in those two different types here in a minute. So the two types of trust that we typically see are a revocable trust. And a revocable trust is mainly set up for probate avoidance, and that's probate while you're alive through an incapacity situation, and also probate when you pass away. So a revocable trust can handle both of those situations of probate and make sure that you do not have to go through the probate process, hire an attorney, go in front of the probate judge, and your family has to go through all of that. So a revocable trust does a great job of probate avoidance and getting a lot of getting a lot of stuff done before you pass away, so you don't leave that to your family to deal with. You kind of almost probate it in advance, so to speak. So revocable trusts are used really widely for probate avoidance. Now, a revocable trust does not protect assets. It does not protect you from lawsuits and estate taxes and those type of things. It is strictly designed for probate avoidance. So the second type of trust we see is irrevocable trust. So an irrevocable trust, and there's a lot of different types of irrevocable trust, typically are set up for asset protection. Okay. So from nursing home planning, VA aid and attendance, lawsuit protection, and estate taxes. So these are some of the things that an irrevocable trust may be set up to help you plan for. So those are the two main types of trust. The revocable trust. Revocable means you can revoke it. You remain in control. You are basically acting as your own trustee of your trust, and you control it just like you do now. When you get into the second type of trust, is the irrevocable, you start to lose control over the assets in the trust, and it becomes, like it says, irrevocable. Now, there are different types of irrevocable trust, and there are ways that irrevocable trust can be dissolved and changed. But in generally speaking, revocable means I maintain full autonomy, control over my asset. Irrevocable, I'm starting to lose that control over that asset. So, you have to be careful when you're looking at different trusts and estate plans to find out what are you trying to accomplish, and what is important to you, your family, and how much control are you willing to give up to get some of that, some of those protections in your estate plan. So I think it's a great conversation to have with your advisor, with your attorney, sitting down, going over your plan, making sure that it really is on pace and does what you want it to do. And I hope that helps y'all. I hope y'all have a great week. It's starting to get chilly out there. I got my jacket on in here, which is, I love this type of weather and this time of year. So hope y'all have a great week. God bless, and we'll talk to you soon. Take care.